Thank you, ladies and gentlemen. I'd like to introduce you to Peter Crofts, who will be giving a paper, Making the Best of Financial Issues for Your Client in Property Disputes. Now, for those who don't know Peter is not only a barrister but got a very extensive experience in accounting and forensic examinations. Peter's background is that he's practiced for many years as in-house counsel with Deloitte Touche Tohmatsu. Prior to that, he worked with the National Crime Authority and a city law firm. He's been admitted to practice since 1982 and signed the role of counsel in November 2001. Now, in addition to Peter's legal background, he holds qualifications in accountancy and psychology and is an accredited mediator. He has a wide range of practice in relation to financial matters and a very broad area of practice involving not only family law but also commercial matters. Peter also has a very interesting involvement not only as a part-time lecturer at Melbourne and Monash universities. Until 2006 he was Deputy Chair of the Marine Parks Compensation Appeals Tribunal, and he likes, when he can, to get wet sailing. I'd like to introduce Peter.
Thank you, Richard. It's nice when a gentleman who's taken your major brief from last year introduces you, and then you realise you've got to front him on Monday over subpoenas. When Michael asked that I do this, mornings seemed a very dreadful time to talk about detailed cases and analysis. So this paper is an attempt at simply being practical and raising practical issues for you. I then discovered I was following Therese, and I became even more frightened once I'd seen her slides because, of course, like children, they were all full of colour and movement. And as you can see, on financial issues, we're simply black and white, or perhaps shades of grey. The only advantage is, for those with an accounting background, at least we've used the green auditor's pen. All good counsel tell the court what it is they're basically about before they start. I want to try and cover a couple of topics, really dealing with the financial issues in your case. And the reason I want to do that is that most of us spend an awful lot of time writing detailed affidavits about who did what to whom when. And all of that goes to contribution. Yet nearly everyone in this room will get contribution arguments right within 5 to 10%. But the first step for the court is, as we all know, identifying the assets and liabilities in the matrimonial pool and valuing them. And people don't tend to spend a lot of time on it. They spend all their time on contribution issues. I think you can make a much bigger difference to your client's case by looking at pool and spending time on the financial issues that go to the pool. One of the simplest examples, and I owe this to an instructor, is that instead of simply getting a bank statement and saying that's what's owed on the mortgage, you write to the bank. You say, what's the payout on the mortgage at trial? Of course, until the current reforms went through, the bank would include the penalty for early payout. All your lease clients still will. But when you present to the other side a letter saying the payout on this date is this figure, you've probably added 20 or 30,000 as a liability to the pool, a liability that your client won't have to pay. You haven't misrepresented anything. It's up to the other side to pick it up. But you have identified a bigger liability. And liabilities offer a lot of scope. We know that you're not going to get a hearing in 9 to 12 months, generally speaking. So probably you're going to have the chance for your client to draw business accounts. So get them to do the review of their accounts that they should do. Look at bad debts that have to be written off. I had a matter where we got a plant and equipment valuer in. The plant and equipment valuer went and valued the spare parts and stock, and it was all junk. There was very little value in it. Very fortunately for me, the husband answering my questions in cross-examination said, oh yes, he knew that there was no value in it. Then turned it to the accounts, which he'd signed only 3 months before, and there was the spare parts and stock valued at 120 grand. So I was able to suggest to him that the accounts were wrong, and he had to admit they were. And he'd signed them 3 months ago. What else was wrong in the accounts? If you are going to have another set of accounts done, please get your clients to spend time on them, because you should be able to review them, not because they want a loan for the bank, upping all the assets, but because in this occasion you want to maximise the liabilities to prepare for their forthcoming property case. I think you can probably classify both clients and probably our opponents into people who disclose or people who obfuscate. Try and say that 5 times quickly. Sometimes there is someone who has economic control, knows what's happening, and has the ability to make an election, if it is an election, to eke out information to the other side in the hope that the time, cost and effort of gaining information will cause them to settle. I'll come back to those. There is, of course, the reverse side. Usually you're for the wife. How the heck do you get the information? But the vast majority of cases, in my view, fall into a different category. Both parties now have sufficient information, or their solicitors do, that obfuscating really doesn't get you very far. It simply means subpoenas and further effort by usually the wife to elucidate the matrimonial pool. I think, therefore, the opportunities for people to obfuscate are often overstated. There is, of course, yet a fourth category of people, and these are those whose finances are in such a mess that they really don't know what the position is. It's not a matter of obfuscating, they just really don't know. And I think with those people, you've got a duty to sit down and talk to them about the advantages and disadvantages of actually getting it right and working with their accountant or with someone to sort out what the mess is. It's going to have to be sorted out at some point, and it may well be better sorted out and all of the liabilities properly quantified. I feel more comfortable speaking today because I settled the matter yesterday. The real issue there was that the husband's business had suffered a loss of suppliers, it had crashed, there were very significant debts. I don't think there was any debate that there were significant debts. The debate was how big were they and what were the assets that were available to offset them. Now, in my view, the husband's advisors took a tactically wrong decision in that they simply didn't do anything about it. As a result, for the purposes of settlement, they conceded that, oh, there were all these debts, but he would be responsible for them. Now, I would think that on the analysis we'd done, particularly when there was 81,000 owed to the tax office, he was in real strife. And I think they would have been much better off to have done a detailed analysis, had someone properly work out what he was owing. It would have helped them in their negotiations with the tax office. It may be that he went and did a Part 10, which would have put my client in a much worse position than she was. But basically, we took the majority of what was left and walked away. I don't think they really assisted him because they didn't do the work and encourage him to understand. Of course, if you think you're going to obfuscate, remember you've got a duty to disclose. And at least we as practitioners have got to bang that into our clients' heads. But the starting point for that is, what do you need to disclose? Yes, the court rules provide some guidelines, 3 years accounts, tax returns, but is that what's really relevant? And if you're going to take or do the best for your client on financial issues, what you really need to do is to understand the structure and what makes the business tick. In the paper, I've used the example of a solicitor's office. Your client walks in, and this has happened to me with a country solicitor, and says, oh yeah, I'm in partnership with 2 other blokes. So the disclosure that had gone on the statement of financial circumstances was interest in partnership, 33 1/3%. If it was a 2-person partnership, it would have been 50%. In fact, had anyone actually done any work, that's not the case at all. There's an incorporated practice in which the partners hold shares, so there was a 3rd interest in that partnership. There was the underlying service trust, which owned all the office equipment, employed the service staff, etc. Who was the appointer of the trust? The 3 partners. Is that matrimonial property? Debatably, it's not. We don't have control of the trust. 2 others can outvote us. There was also the conveyancing company. The long-term conveyancing clerk had a 30% interest. The other interests were shared. So at the very best, we've got a minority share in a conveyancing company. We haven't got a 30 or 50% share in a partnership. We've got a 30% share in 1/3 of the business. Very, very different issue. Had the solicitors either checked, spoken to his accountant, or even done the process of, let's do a directors and shareholders search with ASIC, what companies is he involved with, then let's search those companies, then let's do an index search for land owned by those companies. They're the basic steps to sorting out the corporate structure of your client. And if you can't get it from your client or his accountant, you really ought to do it yourself, because otherwise you make silly disclosures in your very first statement of financial circumstances, and they keep coming back to haunt you. Oh, we got it wrong. Here's a solicitor who got his structure wrong. He didn't get it wrong. It's all really conducted as a partnership, isn't it? You've really got an interest in 1/3 in the lot. And basically it's all conceded. Too late to try and claw it back. What that really means, once you start to understand, is that your disclosure can start going to the things that you want it to. I'm jumping ahead of myself in the slides, but sticking with the theme, that solicitor's structure is going to have to be valued. Now, what is it that people are looking for in the valuation? Well, we all know that typically the independent accountant's going to turn around and come up with future maintainable earnings, what he reckons the practice will continue, or she will continue to earn in the period going forward. And they're going to capitalise that. Capitalising it means, in effect, how certain are we that they are going to keep earning this? But if you think of a solicitor's practice, there are different types and quality of fees, aren't there? Family law fees, except for the issue that I'm going to talk to you about at the very end, probably aren't terribly much repeat business. You see them once, they're so desperate to get rid of the baggage that that's the end of it. On the other hand, retail leases, all referred to you by 2 of the estate agents in town, are probably much more consistent fees. You might act for an insurance company or be on the government panel. So in your disclosure, you want to be thinking about, what is it that might produce the result I want? Oh, of our fees, 40% are family law. You tell the other side, you're also telling the independent expert, who, if they're doing their job, might well say, oh, if 40% of it's one-off work, I'll decrease my multiple. Therefore, the value of the business is less. And that goes to understanding what it is that your client has, what the financial issues are, and targeting your disclosure to the things that assist your client. The real problem, however, for most of us, is dealing with the obfuscators. Now, I've had some debate with some of you here today about just how you do this. My concern as counsel is that it gets confused. We all know that when you get your first stack of information, you're going to go through it and you will identify further issues or problems. And it might take 2, 3, even 4 iterations of documents to get enough to come up with a value. I'm currently arbitrator in a matter, and I think we're probably on to our 5th iteration of convincing people to provide us with information. What tends to happen in my experience is you ask for 10 documents, you get 6. So you look at them all. And then you write back saying, please give me the other 4, and based on the 6 I've looked at, I need 5 more. So you then get 1 of the ones from the 6 and 2 of the ones from the 5. So you write your next letter. I'm still missing this from the first, this from the second, and now I've got the 3rd request. Now, when I get up to do the interim hearing where I say they're failing to disclose, first of all, if you haven't summarised all of that in the affidavit in a nice little schedule saying this is when I requested it and this is still missing, then I've got to do it, and you should do it in your affidavit. But secondly, I've got to take the court through a chain of correspondence. And let me assure you, the registrars all get sick of it. All they're interested in is, do you really need it? And I think it's a much better process to simply say, I've asked for my 10, give them to me. And almost to put them on a shelf. Because otherwise, you've reviewed them when you got 6, you then got 3 more, so you reviewed them at 9, then you review them at 10 and send out your request. So you've done 3 reviews when 1 would have done in terms of cost for your client. And it's a lot easier for me to go along and say, there was 1 request, Your Honour, all 3 are missing, or it's taken 3 follow-ups and we still haven't got them all. That's it. Order. Because I'm trying to do 2 things. Not only do I want the documents, but I also want to get through to the court that the other side are obfuscating. They are failing to disclose. I want to taint their position, set it up for the final trial so that I can argue Weiss and those cases failure to disclose. Now, I think as a group of practitioners, we are tending, as we often do, to cut to, oh, well, this'll do, I've got this much information. And we all know that there are obfuscators amongst the practitioners we deal with. And I think some of those we have, as a group, got to take on and run interim applications and run them simply. Otherwise, there will continue to be huge failures to disclose, trial affidavits presented 2 days before trial with new information. The judges might rant and rave all they like, but the end result is, in order to avoid adjournments, further delays, we all tend to run on without them. And that goes back to chasing the information and not letting the obfuscator get away with it very early on. If you're going to do financially good things for your client, then you've got to learn to deal with experts. I said I'd jumped ahead, but don't assume that the expert will deal with the basis of valuation properly. There's an outstanding judgment before Justice Bennett at the moment on this point, and we'll make sure that on Green's List website something goes up about it when it comes through. But we all know that the concept of value to owner is something that has been well accepted by the family court. The decisions about value to owner tend to be about family companies, where there is, in the words of the Corporations Law, a closely held interest, but within the family. I don't see any reason why that shouldn't extend to all closely held corporations, closely held corporation being something with a small group of shareholders. They all tend to favour the person who's the shareholder. Most valuers start their report citing Spencer and the Commonwealth. I am asked to value this business. What is a fair value? A fair value is that paid by a willing but not anxious purchaser to a willing but not anxious vendor. And they go to market. They go to future maintainable earnings. They don't sit back and think, is there a basis for valuing this as value to owner? And if you have any doubt, stick it in your instructions. Please consider whether a valuation to owner or market value are applicable, and if there is any doubt, do both. It's after all an issue for the judge to deal with, not the valuer. Valuer might care to give you reasons. But often the value to owner opens up a higher value, which if you're for the wife, you really want. Now, if it's a single expert and you're having problems with the other side, don't get fussed about, oh, I've got to give in. All arguments, save one I've had over letter of instructions to single experts, have been dealt with very promptly by the registrars and dealt with over the phone. Here are the two letters, this is the issue, and they're done. I think that's being a good lawyer and pushing your client's interest. I've talked about shaping the valuation by what you disclose and by bringing to the attention of the valuer the things that might affect the way they see the valuation. There is also the issue of what their valuation means. One of the intellectual issues, if that's the right way to describe it, that intrigues me, is when we're valuing future maintainable earnings, think of a little electricity, we're a little electrical suppliers business. They sell switches, they do have some staff that install cable, run through a company, usually a trust underneath. Essential owners are husband and wife. So the valuer's gone out and he said, well, I think they're going to make 120 grand a year. That's after paying the husband an adjusted fair salary of 65 plus his motor vehicle. I'll capitalise the 120 at 3, so the business is worth 360. Husband already owns half of that, 180 grand, so he's buying the other 180 grand from the wife, or he's in effect buying the other half of the business from the wife, and he's paying her that 180, which is the capitalised income. Then we get to section 75(2) factors, and we say, husband's going to earn a salary of 68 and he's going to make a profit of a further 80 grand on the business, so his future earning capacity is 148 or 150,000. Wife's a kindergarten teacher, she's on 40. There should be an adjustment on 75(2). But isn't that double counting? He's just in the property pool paid for that future income earning ability. Now, for those of you who are about to throw Cunningham and Cunningham to me, it is true that it was considered in Cunningham and Cunningham, and the court says, in effect, in all the circumstances of the case, it's all right if the court considers both. But there's another way of putting the same argument. In those circumstances, how's hubby going to fund it? He's going to have to go off and borrow. He hasn't got another 168,000 sitting in his pocket, or whatever it is he's got to pay the wife. So who's actually thought it through? These are the orders we want. You've got to put in your case outline the effect of the orders. One of the effect of the orders is hubby's going to have to borrow 200. Because he hasn't got enough land to put up, he's going to be paying 10% interest. Therefore, there's a 20,000 expense that he will incur going forward. No reason why the letter from the bank can't be exhibited, no reason why that information can't be put forward. And at the very least, it's got to be considered under 75(2). but that's a matter of you thinking through what the effect of the orders are and preparing them. When I start talking tax, lots of family lawyers immediately run the other way. I accept that at least running to someone's accountant and getting them to sign off on it is a very good risk reduction measure, and I would encourage you to do so. Let me go back a step. When you run to accountants, when I was one, I used to think I could play a much greater role in family law settlements and was keen to work with the solicitors to do so. Having been at the bar for 10 years, I'm a bit concerned at the number of not so good accountants that are out there. And I think it's very important that if you are going to use accountants, you keep some degree of control over them. In the paper I talk about allowing the accountant to go and do the inspection of documents, or meet the other accountant, or allowing dealing with disclosure by saying, oh, go and talk to my accountant. I think all of those only produce problems. I think as the lawyers running the case, we have to be involved in that process. And I provide some examples in the paper of where the accountant has either deliberately taken a view of being difficult because their continuing client is one side, or where, because they didn't have an appreciation of the points that we wanted to make, they made concessions or let things go that probably were not beneficial. Now, I know I can't direct them in a joint conference, but working with them means that they start to understand where you're coming from. And I encourage you to work with the accountants, because that helps you gain the understanding of the financial issues that I'm suggesting is necessary to do the best for your client. One of the things that I would encourage you to do, however, is when you get valuations, what tends to happen is people say, oh, I've offset loan accounts, or I've disregarded inter-entity and inter-party loan accounts. The position might be that the business has paid the parties not just the $50,000 salary that they were each paying for on PAYG, but it's given them another $30,000 to buy a car or have an overseas trip. That's recorded as a loan. The company has lent to the parties a loan. It should, except that we never prepare them, be recorded in the balance sheet of the parties as we owe the company $30,000. And because the two offset each other when you arrive at the matrimonial pool, most accountants preparing expert statements disregard them. I think it's quite dangerous, because by disregarding it, what they do is they don't alert you to Division 7A problems. It is those loans or loans to now trusts that have tax consequences. And I would encourage you in instructing experts to say that you did not want loans ignored, that you wanted all the loans recorded, because you can then look and see if such loans exist and say, I've got a tax problem here, I need some further assistance. There is also the issue of understanding tax. Remember that tax isn't always a payment. It can in fact be a substantive refund. One of the issues on disclosure is Untitled 3 years tax returns. Go look at them. See what the practice has been. You don't particularly want to settle up and then discover that the other party gets a $12,000, $15,000, $20,000 tax refund that you hadn't taken into account. And too often the tax liability or the tax refund are simply ignored because we're doing it on what happened last year, not what will happen in the financial year going forward. And often that difference is quite significant, because one party will have been paying tax on the basis that they were going to have the same interest in the company or the business that they had in the past year. But of course they haven't, because they've separated, they've stopped getting any payments. So when they put in their tax return, there is a big refund for all the tax that has been being paid on their behalf by the company. There are also financial issues when you come to settle orders. What often happens is we all know what we mean when we draw the orders, but off they go to the accountant to implement, and the accountant puts a different spin on them. I have the misfortune about once a year to be briefed on a negligence claim where someone's either wanting to sue or be protected over orders that were misdrafted, or more correctly, orders that were not drafted with sufficient detail that the accountant couldn't change them around later. The biggest issue and the biggest thing to be aware of is where there is some suggestion of, oh, we'll wind up the company and pay out dividends. It is not usually very easy to do that without tax benefits or tax issues arising. Most recent example was an issue where the orders that had been made, the parties caused the sum of $215,000 to be paid from the company to the husband. That's all right. Issue, should we have joined the company to make the company bound to do it, but the husband and wife were both directors, they're shareholders, they can affect it. That each of the husband and wife forthwith do all acts and things and when called upon in accordance with the advice received from the parties' external accountants, including in the capacity of the parties as directors and shareholders, such that the company be wound up and its assets sold. The parties and directors and shareholders of the company declare such fully franked dividends to themselves for any relevant financial year as is advised by the accountants, and do all acts and things necessary to complete the winding up of the company. And the net result there was that the $215,000 was paid as a dividend. The $215,000 as a dividend was taxable in the husband's hands. Because he was then working as an overseas consultant, he got taxed at 48%. He thought he was ending up with $215,000 cash. He ended up with $107,000 or $110,000 cash. He was not a happy man, but it was quite available on the orders. I have from time to time, and you can do this with the assistance of your accountant, actually set out in orders the accounting transactions that need to be undertaken. So that the company shall pay this and record it as this. I regret that I've had a couple of occasions where the judges have refused to accept that, saying they couldn't do so without having accounting evidence, although in the Federal Magistrates Court, definitely Walters has been happy to, and some of the others. In order to let you all go by 9 and leave some time for questions, I want to jump to one last issue. When Michael asked us to present these papers, he gathered those of us who practice in family law on Green's List, and it's starting to become quite a nice little coterie of people who can exchange comments, which is one of the nice things about the bar. And what intrigued me was that a number of the people sitting around the table said to me, why don't family lawyers do more with their clients afterwards? And it's been an issue that's troubled me ever since I've been at the bar. My client yesterday, who in effect kept what we had, was going to have to go off and refinance the home to pay out the mortgages so that there was no further mortgages in joint names. I think it will be the first time she's been to visit a bank manager. I'm not at all sure that the bank is on her side. At what point do you stop acting for your client when they have been, in effect, seeing you for 12 months on at least a monthly basis, perhaps in the last 3 months as you've prepared for trial on a weekly basis, perhaps in the last 2 weeks almost daily? During this very difficult period of time, you've become the crutch they lean on. And then a lot of family lawyers tend to say, oh, well, I'm only experienced in family law. Here's the bill. Client looks at the bill and says, oh, I don't want to see them anymore, and runs away. I know that there's at least one financial planner in the room. She may care to comment, but I think there is an opportunity, particularly when your client is getting money, to organise for your client a parade of financial planners. Come and see 2 of them with me. We'll help you get some advice on what you do with your money. Come and see me in a month's time and tell me how you're going with the settlement. Go and see the accountant. Talk about the wills and the powers of attorney that need to be changed. The next step is educating them about financial agreements. It's the subject, I suppose, of a separate paper, how binding they are. But look at the figures. 33% of first marriages end up in separation, 50% of second. 1 in 2 of your clients has the chance of coming back. Ruin your valuation of your practice. But it's the one thing that accountants have over particularly family lawyers. They see their clients every year. And it's through that they form the relationships that see the accountants sometimes take over family court settlements and basically run them for us, which is, in my experience, not the right way to let it happen. So if I can leave you with a practice development idea, that means maybe if you didn't brief Green's List on the first divorce, you might on the second. Thank you very much.
Thanks very much, Peter. And if I could invite anyone who has a question of Peter to fire them at him, and he'll be more than happy to answer. We've got a few minutes and to see if anyone's interested in getting a bit of further advice from Peter whilst we've got this opportunity. Down the back.
Just throwing in a comment on the last one. It's an analogous area, I think, not only commercial but family crime as well. The young kid who should have got in, I kicked him out. Partner's family who basically funded me. The first comment after kicking him out on the Monday was, "You're now our family lawyer." So I fostered that relationship with the father, who's in a major building project that in game is now looking to potentially come over and use me as well. I'm not building up myself, but it's exactly that point. Family and crime tend to be areas that I've seen in 20 odd years of practice where practitioners don't tend to follow through. And yet, as you say, and as this example given, the prime examples of it, you've done a good job, even if it's cost a lot. They're happy, you foster that relationship, and you don't know what you're going to get out of it.
Look, I absolutely agree with you. Thank you for the supportive comment. I can see that in specialist family law firms it's perhaps a separate issue, although whether they see opportunity in adding wills and probate divisions or something else, I'm not sure. But even then, it gives them the opportunity to maintain a relationship for future family law work and referrals to a commercial firm who might give the referrals back. And it just keeps hitting me between the eyes that it's an area for practice development.
As the financial planner referred to, obviously I typically work with the wives, who typically are the receivers of the settlements, and as you know, very often have very little financial experience themselves. They've been reliant on their husbands who run the businesses, who run the mortgages, who run the books every week, make sure the bills get paid, etc., etc., etc. Obviously, I take all of that into consideration when I provide my advice to them. But what I see in many law firms, and I promote this to you, is that there is a value add at the end of the process to revisit wills, powers of attorney, etc., which builds up your practice and promotes other areas of your own business.
Thank you, Catherine.
Peter, in your experience, where there's a dispute as to the mode of valuation, particularly value to owner, to what extent are trial judges plugged into that method as opposed to the other option available?
You've got to have a basis for value to owner. If you read Lonergan or some of the valuation texts, there is good legal argument that the best valuation is comparative market sales. The problem with businesses is that step outside the milk bar, the petrol station, getting comparative market sales is hard. Then the issue becomes, is there something that you can use to support a value to owner? So, for example, is this an issue where there has been a recent change? There are 4 mates in the building business, one's just retired and a young bloke's come in. Does that give me a measure that I can use? Are there other benefits? Because the husband is an agricultural consultant, he gets to travel the world, and because he is interested, like Paul Keating, in clocks, it vastly facilitates his clock collection. Is there something that adds because of it? Then you've got an opportunity to build the value to owner case. If you don't have the factual matrix, there is no opportunity. And I'll tell you after Justice Bennett delivers her decision what the current thinking is, but definitely if you can build the value to owner case, I'm not having difficulty getting judges to listen to it, but it's up to you to do so. The problem I have is that people don't think of it. They say to their valuer, please value the business. The value says Spencer and the Commonwealth, future maintainable earnings, bang. And at that stage, if I'm trying to build a value to owner case, I'm fighting the single expert, and that makes it much more costly and much harder.
Thank you, Peter. That looks like a wrap. I'd like to thank Peter and also Therese for the very interesting papers that they've presented today, and I'd invite you to join with me in thanking them this morning.